Hello, and I'm very sorry that I can't be with you this afternoon, but I'm at a conference with Finance Against Slavery and Trafficking in Cape Town, where we're really looking at what more could be done in the great continent of Africa. So I hope you have a good discussion. But I wanted to say a few comments about this report. I mean, the first thing to say is, of course, I wrote a foreword for it, so I very much welcome it. And very pleased to write the foreword, but very pleased to comment on the report. And I think it's symptomatic of an international shift away from voluntarism to more regulation and more legislation. And it seems to me, whether you're talking about the United States of America, whether you're talking about Australia and New Zealand, whether you're talking about Europe, there is a general shift across to more regulation. I think a sense in which waiting for people to do the right thing voluntarily is just taking too long. And I think the other thing, before I talk about the particular recommendations, is the acknowledgement that it's really important that the United Nations guiding principles on business and human rights are a thread running right through this. So I do have a huge amount of sympathy for multinational companies if they're expected to comply with regimes that are very different in many different parts of the globe. And the more that we can help to develop more consistent standards and more consistent law, I think the better. So hopefully it's helpful, but I've read through the report and the recommendations, and I was just going to make some comments on each one of them. The first one, recommendation one, where you're talking about the application to both private and public bodies, I think is really important. In the UK, our Modern Slavery Act, all the provisions around business under Section 54 just applied to the private sector. I think there's a general view now that that was a mistake. The government have acknowledged the need to extend the provisions to the public sector, and in the Queen's speech in May this year announced that they would do that. A recent example, which for me illustrates why this is so important. I was aware that Supermax, which is a company based in Malaysia, which manufactures rubber gloves, had last October, I think, a withhold release order, an import ban imposed by the United States. And then just a few weeks later, the same company were put on a procurement contract in the UK. Now, how can that be right? And I do think if it was the case in law that the provisions applied to the public sector, it would reduce the likelihood of that happening. The second recommendation is very much about transparency and transparency beyond Tier 1. We know there is very little transparency beyond Tier 1, beyond those contractual relationships. But I would also suggest that you need to think about transparency and disclosure. It's not just about being transparent with the company, it's how much do they actually disclose what's going on. Recommendation 3 is about mandating due diligence, both environmental and human rights due diligence. I'm still unclear about the benefits of mandating it in law, in as much as there is legislation in a couple of countries. The French example is the most obvious cited, and there is legislation now in other countries such as Germany. But it's such early days, and it's quite difficult to understand whether this really does protect the most vulnerable workers from exploitation. Because my view is that there is forced labour in most international supply chains, and what we should be doing is encouraging businesses to find it and address it. And the issue for me is the extent to which we have evidence that mandating due diligence helps us with that task. And I guess the bottom line, as I said, is how clear are we that it benefits the exploited worker? Recommendation 4 talks about reporting mandating categories of information. Again, that's something which the United Kingdom government have in the Queen's speech said that they're going to move to that. I think that's right. Otherwise, you end up with tremendously variable quality of any statements, of any disclosure, and I think mandating what's reported can be very helpful. Linked to that is the proposal in recommendation 5 for a registry. Again, we have a registry in the UK, but it's not mandated for companies to upload their statements to the registry. The proposal in legislation is for that to happen, and I very much support that. Recommendation 6 is about the Anti-Slavery Commissioner, a subject close to my heart. I do think it's really important to have somebody who stands in a way outside government, but also outside a campaigning sector, and can use evidence and data to speak truth unto power. Couple of thoughts about reflecting on my own experience. The UK approach is a 3-year term. I suggest that 3 years isn't sufficiently long. I think 5 or 7 will be better, because you need to have confidence that you can speak the truth and you're not reliant on a government who you might be upsetting renewing your contract. So I think that's really important. And particularly in the UK at the moment, there is no commissioner being appointed, and we have a government that's making very concerning comments about alleged abuse of the Modern Slavery Act provisions, and there is nobody to stand up and say, well, actually, the truth is, the data says, the evidence is. So I think it's really, really important. You also suggest in recommendation 7 an advisory group. That seems really good to me. There's been a sort of advisory group, a sort of strategy group in the UK. Early days, ministers would chair and attend and took concerns seriously. Over recent years, I'm afraid that level of interest has declined substantially, and I think a real frustration from those in the strategy group as to whether their voices are being listened to, let alone heard or acted upon. Recommendation 8 about greater accountability. Whether it's fines or whether it's import bans, you need something that's going to grab the attention of the C-suite, so that this is a top issue that is a material risk to a company, and therefore action needs to be taken. So I'm in favour of those sorts of recommendations you make. In terms of remedy and liability, I'm continually concerned about the very, very few occasions that companies ever provide remedy to workers who've been exploited. I guess the exception to that is the Malaysian rubber industry, where over $100 million in remedy has been paid by a variety of companies as a result of import bans. So I think remedy is something that we really need to look at. I also think that it's worth looking at proposals that were made in the UK for a duty to prevent forced labour, and with a defence that you've taken all reasonable due diligence steps. It's the sort of approach that we have to fraud, and I think it's worth looking at in terms of just tightening and upping the pressure on businesses to make the right decisions. And lastly, recommendation 10, and I was wondering whether you would ever get to this, but it's the suggestion that you should look at import bans. I think that the US deployment of import bans, both under the Tariff Act and into the Uyghur Forced Labour Protection Act, are proving to be extremely effective. I hosted a conference last week, and we had Customs and Border Protection talking about their approach. We had an NGO talking about their contribution, and we had a business talking about the impact and the way in which the import ban, all the steps they'd had to take to have it removed, had really made a huge difference to the way the business operated, and most importantly, had significantly changed the experiences of the most vulnerable workers. So hopefully that's a useful run through the recommendations. I hope I haven't spoilt the next presentation if you were going to do that, and I wish you good discussions and good to be with you, if only on video. Thanks a lot. Bye-bye.